allegedly requested for him to cooperate in terms of the alleged match fixing.
Yes.
If there were such facts pointing to that collusion, allegedly, or perhaps things which were detrimental to the player, even if he did not participate in the match fixing, if he reviewed information in his mobile phone, could there be imminent danger stemming from the fact that his father has ties to, I think I read somewhere, ties to the underworld?
Well, if you're talking about communications between the appellant and his father himself, wouldn't it naturally follow that any communication found on the appellant's phone will also be found on the father's phone? As the nature of communication is that it's two-way, that will be located, and such messages will have been located on the father's phone as well. And notably, in our proceedings today, it is the appellant, Mr. Fortuna, against FIFA, not not the appellant's father. And therefore, in today's proceedings, we must ensure that the appellant's rights are respected. Mr. Fortuna's father is of a separate issue, and he faces his own his own criminal trial before the Iridonian public prosecutors, which have to, by their own methods, find a way to find Mr. Fortuna's father guilty of the crimes they are accusing him of. And crucially, as noted in Article 12, subsection 5 of the FDC, this court is bound by the facts that's already present to them. And essentially, this means that if the appellant had indeed refused to hand over his handphone, which he had, the courts are bound by the evidence that are already present to them to make a finding. They are not allowed to use maybe the doctrine of adverse inference from the fact that the appellant had refused to hand over his phone to find that the father was guilty of match fixing, or that the appellant himself was colluding in match fixing. Rather, they are confined to whatever they've already been provided to find whether the appellant himself was guilty of match fixing under Article 20 of the FDC.
Is there anywhere in the record which points to some solutions or workarounds proposed by the player himself? I mean, what I'm thinking of is, instead of handing over the whole mobile phone, perhaps there could be some redaction or selected messages where he can review to FIFA. Was there anything of that sort in the record?
On the facts of the case, there currently is not. And notably, with regards to Article 6 of the CHR, which is the right against self-incrimination, I do believe that the respondent and the appellant can come to a consensus as to what degree of information can be shared from his phone. And notably, we have to ensure that his rights against self-incrimination is protected, but we do believe that mutual cooperation can allow us to identify any information in his phone that do not breach his right to self-incrimination, but at the same time do aid in our processes in finding whether he indeed be liable for match fixing. Crucially, we do note that it does have a certain optic that the appellant, despite claiming that he did not collude in match fixing, refuses to hand over his phone. And to ensure that he indeed is innocent, we would like to try our very best to help him by ensuring that his right against self-incrimination isn't violated.
So my question was there anywhere in the record where either FIFA or the player himself suggested all these solutions? That's all.
No, Mr. Arbitrator.
Okay, sure. Then go on.
Actually, Mr. Arbitrator, that about sums up my submissions. If you have any further questions. This concludes my submissions. I'll now hand over my time to my co-counsel, Mr. Ramesh Kanna, who will address the remaining two issues on appeal. Thank you.
So, Mr. Ramesh will be speaking on behalf of FIFA, right?
Yes.
Yes, with the understanding that the appellant has
Good evening, Mr. President. My name is Ramesh Kanna and I act for the respondent, FIFA, and I'll address two issues in today's submission. Firstly, whether the anonymous witness statement and the anonymous email are admissible, and secondly, whether the appellant has breached Article 20 of the FIFA Disciplinary Code. Now, with regard to admissibility of the anonymous evidence, the legal framework that is to be adopted is firstly the FIFA Disciplinary Code and secondly the CAS jurisprudence. Both these sets of legal frameworks have to be satisfied in order for both these pieces of evidence to be admissible. Now, I note that Mr. President had earlier posed the question of what rules of evidence that he is bound by, and this is relevant for this issue as well, given that it's an admissibility issue. And it's worth noting that in the CAS code, there's no direct article with regard to anonymous evidence of admissibility of anonymous evidence. However, there are broad conceptions of fairness, such as equality of arms, which is stated in Article R44.2 of the CAS code. And what this translates to is, this is interpreted by the CAS jurisprudence, such as the 2010 decision of UEFA and Orikov, where the panel confirmed that comfortable satisfaction is the correct standard in corruption cases, and explicitly noted that corruption is typically proven on the basis of indicia and circumstantial evidence and not proof. So basically what these line of cases do is that they have interpreted this broader idea to come up with rules within case law. However, there's no particular article within the code that directly addresses this issue.
Then what about Swiss law?
Unfortunately, I do not have that at hand, Mr. President. But it's worth noting that this is also aligned with Article 39 of the FDC on evidence and standard of proof, which provides three key points. Firstly, that any type of proof may be produced, and second, that the judicial body enjoys absolute discretion regarding the evaluation of evidence, and thirdly, that the applicable standard is, once again, comfortable satisfaction and not the criminal standard of proof beyond reasonable doubt.
Judicial body. Those are the FDC. Where's the FDC?
Yes.
What's the definition of judicial body? And is the CAS panel a judicial body?
No, Mr. President, the CAS panel would not fall within the definition of judicial body as conceived by the FDC. The FDC governs rules of evidence within disciplinary hearings that are conducted by the FDC. However,
So
this
you're saying that the CAS panel is not bound to those rules?
it's not bound by it. However, given the fact that I am here to prove admissibility, I have to prove that it coheres with both the FDC standard and the CAS jurisprudence standard. Now, the 2009 CAS decision of FK Pobeda and UEFA. Oh.
Sorry, just a little bit of annoyance, but can you say CAS and UEFA?
CAS and UEFA.
Yeah, thank you.
Understood. So similarly in this decision, the CAS aligned match fixing with doping jurisprudence, accepting that disciplinary bodies can rely on indirect evidence provided they meet the comfortable satisfaction standard. And now when we apply this to the present case, firstly with regard to the anonymous witness statement, which is on Exhibit 2 at page 9 of the record.
Page 9 or
Moot problem. No, the moot problem.
Sorry, page 9?
Wait, apologies.
Which exhibit are we
If I could refer to Exhibit 2 of the record.
Okay, I am there.
Under the section titled My Reasons for Requesting Anonymity, The witness explains that he fears reprisals because the appellant's father is rumored to be connected to criminal organizations. Now, this is a textbook Article 43, subsection 1 FDC situation, where disclosure of identity may trigger threats or intimidation. Now, substantively, this statement is both relevant and reliable because the witness personally observed two key things. First, the appellant was on the phone with his father the night before the match, and second, the appellant shouting that his father should stop pressuring him and that he cannot go along with everything. Now, CAS in the past has accepted this type of evidence where anonymity is justified and the evidence forms part of a corroborated mosaic. This was seen in the 2010 CAS decision of Orikov, where the panel stressed that corruption is by its nature concealed and that sports bodies must often rely on indirect and non-traditional evidence, including information from confidential sources, to reach the comfortable satisfaction standard. And here, our situation is similar because the anonymous witness is one brick in a much larger evidentiary wall. Now, this can be seen when we look at the anonymous email as well, which alleges a transfer of 50,000 Dogecoins coins to the appellant's father. Now, this email is likewise admissible and it is importantly heavily corroborated because in Exhibit 5, we see that the prosecutor's press release confirms that Mr. Luke Fortuna's Dogecoin wallet is under investigation by the Specialist Sports Integrity Unit. And secondly, under Exhibit 4, we see that the WhatsApp screenshot shows Luke the crook acknowledging receipt of the last part of the coin from the syndicate. And thirdly, Exhibit 1, the Genius Sports Report, records massive, unjustifiable betting for Cometland and a red integrity alert, exactly the kind of pattern one would expect if a syndicate had paid a key insider. Now, CAS jurisprudence is clear that anonymous intelligence is admissible if it is corroborated by objective data. This was seen in the 2014 CAS decision of Sivasspor and UEFA at paragraphs 124 to 125. And CAS accepted UEFA's betting fraud detection system reports together with other indicia as sufficient evidence of manipulation despite the absence of direct confessions. This was also echoed in the 2013 CAS decision of Besiktas and UEFA. Here, the anonymous email points to crypto payments, and the prosecutor's announcement and the WhatsApp chats and the betting report independently point in the same direction. This is exactly the type of corroborated anonymous intelligence that CAS routinely accepts. And therefore, our position is that the comfortable satisfaction standard is met for both these pieces of evidence. Now, furthermore, if this were not enough, moving to the match-fixing matter, all the hallmarks of match manipulation are present. First, the match was graded red by Genius Sports based on dramatic and unjustifiable odd movements for Cometland and the suspension of markets by major bookmakers such as PiniBet, BetX, and BetAsia.
So the report how objective is it?
Apologies, Mr. President. Give us a moment. Yeah, so okay, could I direct Mr. President to Exhibit 1?
Yes. It's a long report.
Yeah. Okay, we believe that there's actually a printing error with the page in each, the pages.
Because all of them show page 8.
8 in the record.
7 pages from the back.
Yeah, so could I refer you to the page that's 7 pages from the last page?
7 pages from the last page up.
Exhibit 1.
Okay, maybe you can give me a sentence or a phrase where I can use to find.
Maybe you could Control F semi. Oh, sorry, you could just Control F offside technology.
Of site.
Offside, OFFSIDE, spacing technology. And then it should lead you to this section called Introduction, where
Yes.
Genius Reports goes into great detail about what sort of technology they use and the extent of
So your
reliability.
point on the objectivity of this
Falls back on the technology that they use to.
so you are relying on you're trying to say that genius is objective based on what they say.
Yes, and we do not make this statement on thin air because these sorts of reports that talk about betting anomalies have been accepted as objective evidence in previous CAS jurisprudence.
I'm not doubting that. I'm just wondering about the provenance of genius. Is there any external uh, source which can corroborate your assertion, which is that genius is objective, is a credible source?
Okay. Yes, Mr. President. So if I could get you to Control F the phrase the software,
Okay. Yeah.
it would lead you to this section where they state that Genius IQ's Dragon software is now active in 200 plus venues across 33 countries. So the widespread adoption of this particular software that this provider uses shows that it is reliable. And not just that, they go on to add that this robust data set empowers Genius to deliver evidence-driven conclusions unmatched in quality and depth.
I've no doubt whatever they say might be true based on what they say it is. So what I'm trying to look for is whether other sources say that Genius is a credible software provider.
So
That's all.
our submission for that would be that this software is in practice and in use in 200 other venues across 33 other countries.
That's what they say. So is there any external source I can refer to bring that?
I understand the issue. So if Mr. President does not believe the claim as
I
at
don't
the
want to. It's not that I don't believe it. I believe that they're making this claim is probably on good grounds, but I want to be comfortably satisfied. And if I want to be comfortably satisfied, then there should be some other sources saying that they are.
well, Mr. President, I would go on to add that the FIFA Appeal Committee has also relied on this evidence. You can find it in Exhibit 7.
Okay, I think I'm there.
Yeah.
Is
So
there-
if I could refer you to paragraph 33 under that exhibit.
yeah.
So a FIFA Appeal Committee also trusted Genius Reports enough to rely on their report when making their conclusion.
Okay, I get what you're saying. Yeah, but it's still basically your client who's saying Genius report is good, is credible, is objective. Probably something one step removed would be better, but I get your point. Please go.
Yeah, so we wish to highlight again that CAS has repeatedly noted that match fixing is organized, covert, and designed to leave no direct trace. So therefore, tribunals must therefore be able to rely on indirect and even anonymous evidence when that evidence is supported by betting data and performance analysis, as in Orikov and Pobeda. And to conclude, this is the situation that this tribunal faces today. Therefore, both the anonymous witness statement and the anonymous email are admissible as they squarely fit within the CAS jurisprudence and Articles 39, 43, and 44 of the FDC. If members of the tribunal have no further questions, I'll move on to the second issue, which is whether the appellant did violate Article 20 of the FDC. Now, Article 20, subsection 1 of the FDC provides that anyone who directly or indirectly, by an act or omission, unlawfully influences or manipulates the cause or result of a match, or conspires or attempts to do so, shall be sanctioned. Now, if this were to be broken down into three simpler pieces, firstly, indirect involvement is enough. The player does not need to receive money himself. Acting under pressure from or in coordination with a third party, such as his father in this alleged case, or a syndicate, still falls squarely within Article 20, subsection 1. And secondly, attempts and conspiracies are still punishable. The fix does not need to be perfect or fully executed for liability to arise. And finally, the standard of proof is comfortable satisfaction, as confirmed in the cast cases of Orikov, Pobeda, and Sivaspor. Now, match fixing is never shown by one piece of evidence. The cast panel must assess the entire mosaic of circumstantial indicators. Now, firstly, we should look at the betting anomalies. If I could lead the panel to Exhibit 1 to highlight the betting anomalies of the Genius Sports record. If you could look at the pre-game betting section.
Okay, starts with bookmaker coverage.
Yeah, so then could I get you to scroll down to the paragraph which starts off with the markets remained highly stable.
Okay, somewhere in the middle. Okay.
Yes. So in essence, before the match there was strong betting against Iridonia, despite Comet Land being bottom of the group with 1 goal scored and 12 conceded. Now the odds for Comet Land shortened dramatically with no sporting explanation. And in play, within 20 minutes, Comet Land went from a huge outsider to a favourite, even though Iridonia dominated possession and chances. And around the 22nd minute, Pinibet and other major operators suspended markets immediately before Comet Land's first goal. Now, CAS has already accepted in Pobeda and Sivaspor that such sharp, unjustified betting movements, especially when they lead bookmakers to suspend markets, are a strong indicator of manipulation and can be decisive when corroborated by other elements. Now, here these anomalies are not just odd. They align perfectly with financial transfers to the appellant's father, and with performance anomalies on the pitch, and the witness evidence of the pre-match pressure. So our submission is that, indeed, this level of corroboration that CAS jurisprudence looks for has been achieved in this particular case. Now, to develop further on the performance analysis, we submit that there was intentional underperformance on the appellant's part, because the Genius report analyzes and identifies a series of highly unusual actions by the appellant. Now, for the first goal, there was a misjudged, lofted pass over an oncoming forward, which, if I could refer you to the section titled Goals. If you control it.
Performance analysis.
Yeah, right under performance analysis.
Right, so now Genius is going from analyzing betting patterns to technical football analysis.
Yes, Mr. Preston.
Did they list who did the analysis, or again it goes back to the point that I was trying to make, which is how credible are they? But it's okay if you cannot find any information on there. Yeah. So you're saying lofted pass.
Yes, which caused the ball to roll back into the net, which was a blunder in that game. And we do note the nuance that such movements are not uncommon in other games. However, this has to be seen in totem with the mosaic of evidence that's present. Because this was not the only blunder. Earlier, the player also allowed a corner to pass right through his hands.
And where can I find
Give us a moment.
That would be the next page, right? Passages of interest.
Yes.
Okay, 5 minutes 54. So the time is 5 minutes 54. Donia's goalkeeper.
Yeah, and
Okay.
and it was and the player allowed to and the player allowed the ball to pass right through his hands, and he also delayed a clearance until the ball rebounded off an attacker towards the goal. So our position is that throughout the game there are repeated poor positional decisions on the part of the appellant.
Hold on. So how many decisions are we talking about? I mean, up to 554. That's 2, right?
Yes.
So what else is there? Slow back pass. That's the next one. Right?
Yeah.
To get unnecessary extra touch.
However, what is to be particularly noted is that these poor decisions that the appellant would arguably state are genuine began right at the moment when the markets were suspended. In the sense that there is the timeline is such that it's hard not to notice that the players' poor decisions occurred right when the betting movements required it.
So when did the betting movements move again?
At the 22nd minute.
22nd minute.
Yeah.
So from the 22nd minute.
This was right before Comet Land's first goal.
So they were just 4, right? 4 issues with the goalkeeper.
Yeah. And up until this point, there were 12 goals that were conceded on Comet Land's end. So
Sorry, 12 goals?
Sorry, apologies. I retract that statement. I think that was factually wrong, my bad.
Okay, I mean, I hear where you're coming from. I do see that there are 4 mistakes here. But I'm not sure if I'm comfortable with saying 4 mistakes alone would amount to being involved in the match.
Yeah. So to clarify, Mr. President, we're not stating that this is the only evidence that corroborates with the notion that the appellant had intentionally underperformed, but also the fact that there were crypto payments allegedly, and which shows motive and links to a syndicate.
Crypto was paid not to him,
To his father.
to his father.
But when we look at it together with the fact that, according to the witness statement, he was being pressured by his father to allegedly underperform.
But I think the witness statement also said that he was quite not complying with his father's wishes. So, I mean, I'm speculating perhaps, but could it be that he was so pressured by his father and he didn't want to do it, and he was affected by those arguments, and that's why he underperformed, rather than him being told by his father to underperform, and as a result he underperforms. Then I think perhaps Seah needs to come up with a psychologist to interview the guy. Have one more section on the report.
I understand the concern that Mr. President has, and in this regard, CAST jurisprudence has not considered a mental element for this particular article. Rather, it's one of strict liability, arguably, in that the cast panel usually just looks at objective evidence of how the player has performed and the surrounding circumstances such as betting anomalies and other evidence that corroborate the claim that the appellant has been involved indirectly or directly by an act or omission.
So okay, I mean, assuming that these are all possible scenarios or interpretations of the phone call. Okay, one could be that he was pressured and he complied, that's why he underperformed. The other being he was pressured, he didn't want to comply, and but because of those arguments, he underperformed. So if I were to have all these scenarios before me, so two questions come to mind. First, can I, as a panel, and I'm not psychologically trained or psychiatrist trained, can I make that inference that perhaps the scenario B was the case, that he, because of those arguments, his mental state was affected, and that's why he was underperforming? And second, my second question is, how do I consider all these scenarios before me to come to a decision?
Okay, so with regard to Mr. President's first question, as far as the CAS jurisprudence goes and the CAS code goes, the CAS panel would not be fit to psychologically determine the mental state of the player. However, this also goes into answering the second question, which is that the other possible theory that Mr. President had earlier put forward, which is that the player might have underperformed due to the pressure, we would argue that this theory falls apart when we consider the fact that the underperformance matches the exact timing that was required for the betting anomalies to occur. Because if it was a case that the player was pressured from the very beginning, then these mistakes would have occurred throughout the game. Yeah, because at the 2-minute mark, the player was still performing well. And this can be seen at sorry, not the 2-minute mark. At the time 82:43, the player was still performing well.
82:43, that's like almost at the end of the match already. So you're saying that for the whole match he performed well?
As in, he performed well at the end of the game, towards the end of the game. However, the underperformance was only required during the time window where the markets had been suspended. Thus, our argument is that it could not have been a scenario where the underperformance was something that was throughout the game that he was impacted by because of his mental state.
Okay, so what you're saying now is he was instructed to underperform at specific timings. Right. Okay. That I understand. Okay, go on. And I had a second question. Yeah.
Which is what you
if
should.
I had all these scenarios before me, and assuming the answer to my first question is I can make that inference. So how do I consider all these scenarios before me to come to a decision?
So what the CAS jurisprudence has instructed is that when there are more than one particular scenario that has to be accounted for, the tribunal has to look at all the surrounding evidence and consider holistically which theory makes more sense. And in this regard, that is why we submit that given that the underperformance occurred at this particular time, the lack of the fact that it occurs at the particular time that is required for the betting anomalies to be exploited shows that the theory that the respondents put forward is the most viable one that the tribunal should look at. And that brings me to the end of the second issue.
Are there more issues to cover?
No, that brings me to the end of my submissions.
Then I do have one more question. So, I mean, given that your opposing counsel is not around today, how would that play out? How would that play out? Does it affect this particular hearing? Because as the opposing counsel did mention, I do need to hear him, right, on the issues that you're presenting on. Otherwise, it would be a breach of fair trial and right to be heard.
So, as per Article 47 of the CAS Code, hearing can be considered de novo.
I understand what. Okay, what do you mean by de novo?
Unfortunately, I don't think I can assist you on this matter,
Okay,
Mr. President.
right.
I'm quite poorly informed in this regard.
Okay, I understand. All right, then I guess that's all I require of you for now. Are we moving on to rebuttals or something?
Yeah.
And who will be the one?
I will.
Mr. President, 2 points in rebuttal.
Hey, hold on, I'm not ready.
Oh, apologies, Mr. President.
Okay. Yep.
Mr. President, do you have a preference for time for the rebuttal?
No, just go on.
Rather quickly. Okay. Just 2 points. First, the poor performance can be explained, and second, there's no actual link between.
Sorry, you are addressing which issues again?
I will rebut the respondent's issue D or A C on the betting report, the performance.
C is on the anonymous evidence, right?
Or D, apologies, D.
So you're addressing me on the match fixing, the substantive issue of match fixing,
Yes.
and that's it.
And also the issue of the witness statements, the exhibits, the anonymous witness statements.
Okay, so basically C and D.
Yes.
All right, and which one do you want to?
I'll start with the first one, the D. On the,
Sorry, D is the match fixing.
the match fixing.
Okay. Okay. Yeah.
The respondent argued much of his submissions on the betting report analysis, and as queried earlier by Mr. President, it's very objective. May I direct the President to Exhibit 6, which is titled page 15. If you could Control F, my relationship with my father.
Okay.
Exhibit 6 at paragraph 10.
Paragraph 10. Yep.
So here, I quote, I had been feeling a bit under the weather. Line 3, I discussed this with the team's doctor. And so here on the record, he had seen the doctor, had been feeling unwell, and still chose to play. And as a result of which, this could be another reason as to why there had been underperformance of the match. And if there's no further questions, I'll move on to the second point. If I can refer is our submission, there's no causal link between the father and son. And the evidence, the exhibit 3, which is the email, regarding the 50,000 Dodge coins. And the press release Exhibit 5 from the public prosecutor's office does not sufficiently establish causal link. And that's because in Exhibit 3, if President can follow me there, it's Exhibit 3, you can Control F, date, email from anonymous source.
Okay, yeah.
So here in the fourth paragraph of the email says there was multiple.
Starting from the words what I know, from what I know.
Yes, correct. If you see here, I'll quote, the transfer was made in multiple transactions, with transfers happening from the end of September up to the 17th October 2025. And if the president will indulge in returning to page 3 of the record, or sorry, page 2, paragraph, page 3, page 2, paragraph 6, the match occurred on 17 October 2025, and therefore all the multiple transactions that were paid was prior to the happening, prior to the actual game. And this we submit that if there was indeed match fixing, surely these payments would have been paid after one, an agreement had been made, and after the actual game had been fixed. This creates a level of uncertainty in the respondent's case. And then as well as in, just to conclude, Mr. President, Exhibit 5 of the press release here, they only confirmed that Mr. Fortuna had provided access to his Dodge wallet. And
Sorry, Mr. Fortuna as in his father.